Hello, everyone, and welcome to today's Friday Law Talk with Lone Star Legal Aid. Thank you for joining us. This presentation is intended to serve as legal information only. It does not replace legal advice. Contact Lone Star Legal Aid at 1-800-733-8394 or visit our website at www.lonestarlegal.org for more information on legal assistance. Lone Star Legal Aid does not discriminate on the basis of race, color, religion, gender expression, sexual orientation, age, national origin, ancestry, disability, marital status, or military status in any of its activities or operations. I'm Sharanda Robertson. I'm a staff attorney in the Richmond office. And today I'm going to be talking to you about family law, specifically as it pertains to survivors of domestic violence. Family law can be a pretty gray area, and it has a lot of discretion, I would say, when it comes to judges deciding property division and custody orders. We have the standard for custody orders in Texas of best interest of the child. And so a lot of times that boils down to the judge's personal opinion and of what would be best for the children. And so there's a lot of different things they look at for that. But there is a whole lot of nuance, variables. And so some of it, we'll be getting into the weeds of it a little bit, but for the most part, it will be kind of a general overview of family law. So I'll start with divorce. And divorce in Texas, we are what's called a no-fault state. So we do allow no-fault divorces, meaning you can plead grounds of insupportability for a divorce, which means that no party was necessarily at fault or the reason behind the divorce. It's similar to what some other states call irreconcilable differences. And it's simply an inability to continue the marriage. And so that is one aspect that sets Texas apart from some other states, fault-based versus no fault-based. And you can plead either one of those. We still do have the fault-based grounds, such as adultery and cruelty are two of the more common fault-based grounds that we see. And so that is a possibility. But most of the time, we're going to see insupportability as the grounds that are pled for a divorce. The basic steps to the divorce process, the first step is going to be to actually file the divorce. And there will be certain documents that an attorney will draft to begin that process. And after that divorce is filed, the next step is to get the opposing party served, either served or they have the opportunity to sign what's called a waiver of service. Service is usually done by either a constable in the precinct where the opposing party resides, or it can be done by a private process server, someone who is hired to locate the opposing party and hand deliver the documents. That would count as service. Or if the other party, like I said, can sign a waiver of service. That simply says they have received a copy of the lawsuit that's been filed against them and that they are aware that the suit is happening. And it can either be a global one where they say that they don't want to be notified about anything else that happens in the case, which is rare, or it can say that they do want notice of any kind of hearings or future occurrences in the case. And at that point, the opposing party can then decide whether they want to file an answer in the case, which is always advisable that someone files an answer if you're being the one that is being sued for divorce. And that after you're served, you have approximately 20 to 21 days. It's the technical language in the code is the Monday following the expiration of 20 days after the date of service. So you have about 20 to 21 days, give or take, before an answer is due in a case. We also have in Texas a waiting period. No divorce can be finalized any sooner than 60 days after the date that it was filed. So you file on the day you file is day one, and then you would count out 60 days. and the divorce would have to be on file for that amount of time before a judge is allowed to finalize it. There is one exception for that, and that would be if there is domestic violence involved, then you could petition the court to waive that 60-day waiting period. So the next step in the divorce process, after an opposing party is served and or has filed an answer in the case, would be to try to settle the case. There are various ways that you can do that. One popular way is an informal settlement, and that just looks like negotiating back and forth between the parties or between the parties' attorneys, and just trying to reach a resolution with regards to property division, custody, or whatever is at stake in the divorce. If two parties are unable to have a meeting of the minds informally and reach an agreement, the next step might be a more formal process called mediation. And in mediation, you have the two parties as well as their attorneys, and then you have a third party who is neutral, and that's the mediator. And so the mediator's job is to help both parties reach a resolution as quickly and effectively as possible. And basically, they would attempt to act as a liaison between the two parties, facilitate an agreement. They don't provide legal advice, but they would try to help resolve the divorce. And mediation is actually a required step before any kind of contested temporary orders hearing or final trial in a divorce case in most counties. So depending on what court a case is in, that court will have specific rules about when mediation is required in a case. There are ways that you can seek to waive the requirement of mediation. One of those being that there has been family violence in the case. And so you can submit a motion to waive the requirement of mediation based on family violence, and a supporting affidavit to go with that, explaining to the judge why you are requesting that they waive the mediation in your case. And the judge can either grant or deny that order. Mediations can be temporary or they can be final. So for instance, if you want to reach an agreement in your case just for while the case is pending, that is a possibility. And so you could reach an agreement in mediation simply for temporary orders that will be in place until further order of the court. If you would like to, of course, people can go for that final mediation as well, to where any agreement you make that day is going to be the final agreement in the case, and disposes of everything. And at that point, you will be able to draft a final decree of divorce and finalize the case. So it can be temporary or final, and you may go to mediation more than once in that case. If you go before a temporary orders hearing, you can also go again before a final trial. So that's always an option. Another thing about mediation is that most counties, at least the larger ones, have what we call dispute resolution centers. And I know there's one in Harris County, there's one in Montgomery County, and there's one in Fort Bend County. And those actually also serve outlying smaller counties. The dispute resolution centers are designed to be a low-cost alternative to mediation, because mediation can get quite expensive if you go through private mediators, who are usually also licensed attorneys or former judges, and can charge quite a bit for even a half day of mediation. So that can be cost prohibitive to some Texans who are trying to finish a divorce and may not have the income that it takes to go through a private mediation. So if you are in a case and you're needing to go to mediation, I would recommend seeking out the dispute resolution center closest to you and trying to schedule with them. A lot of times they're on a sliding scale for income. And so I know that some people will pay $0 for mediation. Some people will pay $50, and then it can just kind of go up from there. It just depends. Each dispute resolution center has different guidelines. The next step in a case for divorce would be, or could be, temporary orders. Not every case needs temporary orders or goes through the process for getting temporary orders, but oftentimes that is necessary. And again, that would be putting orders in place for while the case is pending until you can get to final trial or get to a final mediation where the case is going to result in an agreed final decree of divorce. So we see this a lot in cases involving children, for instance, because until you have orders from a court, both parents have equal right of access to and possession of their children. And so it might be helpful to have temporary orders that say when each parent is supposed to have possession of the children. It might be helpful to have temporary orders that lay out terms for child support, as well as any other thing that's part of the divorce, such as property, who can stay in the home, the marital residence while the case is pending, things like that. And if you need injunctions, which are court orders that stop someone from doing a specific thing, then that is where you could get some temporary injunctions while the case is pending as well. After that, the next step would be a trial. If you can't reach an agreement in mediation for what the final decree of divorce terms would be, then you would proceed to trial. And there are two types of trial in Texas. We have jury trials and we have bench trials. And bench trial is by far the more common one in family law. That is where it is a judge serving as the fact finder. And so you will not have a jury in that situation. You would simply have the judge hearing the arguments and making all decisions about property division and possession and access of the children. After a trial, the judge will sign a final decree granting the divorce. And it will lay out terms again for dividing up all of the parties' property, anything having to do with children, and possibly a name change if that's requested, anything else like that. The judge will sign off and grant the divorce. And you would be able to get copies of that from the district clerk's office in the county where that's happening. And if you ever need a certified copy, for instance, if you wanted to do a name change after a divorce, or sometimes for other reasons, whether it's changing the title of property, things like that, anything official where you might need a certified copy, you can get that from the district clerk. Usually it's about $1 a page. So, and also you can do that years later. If you ever end up needing a certified copy, it doesn't have to be within a certain time frame. You can always get those from the clerk even later on. Now, one topic that I will get into the weeds on a little bit is spousal maintenance, because it's something that we are asked a lot about as attorneys, and we find that there's, some confusion around that. And so spousal maintenance, sometimes you'll hear it called spousal support, is basically Texas's version of what some other states refer to as alimony. And we don't have alimony in Texas, but it's kind of our version of it. And it's not easy to get in Texas. They have very specific requirements set out in the Texas Family Code for spousal maintenance. And in Texas, our spousal maintenance is only designed to meet the receiving spouse's minimum reasonable needs. And so just to qualify to even get spousal maintenance, the parties must have been married for at least 10 years, and the receiving spouse has to prove that they are unable to earn sufficient income to meet his or her minimum reasonable needs. Another thing that might help someone qualify is if there's been family violence. So for instance, if the spouse who is being asked to pay spousal support was convicted of or received deferred adjudication for an offense constituting family violence within the last 2 years or while a suit was pending, that's going to make the innocent spouse eligible to receive spousal maintenance as well. And again, they're going to have to prove that they're unable to earn income to meet his or her minimum reasonable needs. If someone has like a physical or mental disability, that would be another reason if they're unable to meet their income needs because of that. Another one would be if the spouse who is requesting spousal maintenance is the custodian of a child in the marriage who requires substantial care and personal supervision because of a physical or mental disability that prevents that spouse from earning sufficient income to provide for the spouse's minimum reasonable needs, once again. So if somebody is lucky enough to get past all of the hurdles of qualification, that's the first step, but there are still a lot more that the Family Code lays out. For instance, the spouse who is requesting spousal maintenance still has the burden of proving that he or she has exercised diligence in seeking sufficient income to meet their minimum reasonable needs, or they've exercised diligence in gaining the skills needed to do so. And so that's part of their burden of proof there. And then there are also a lot of factors the court considers in its decision of whether to award the spousal maintenance and for how much and for how long. The Texas Family Code lays out quite a few criteria that the court will consider. One is each spouse's ability to provide for that spouse's minimum reasonable needs independently. The court will consider their financial resources upon the divorce. The court looks at the education and employment skills of the spouses, as well as the time necessary to acquire sufficient education or training to be able to work and meet their minimum reasonable needs, the duration of the marriage, the age, employment history, and earning ability of the spouses, the effect on each spouse's ability to provide for their minimum reasonable needs while providing child support, acts by either spouse resulting in excessive or abnormal expenditures, concealment or fraud, things like that. The court will consider that as well. And the court will consider the contribution of one spouse to the education, training, or increased earning power of the other spouse, as well as the property that was brought into the marriage by either spouse, the contribution of a spouse as a homemaker, marital misconduct, including adultery and cruel treatment by either spouse during the marriage, and any history or pattern of family violence. So, like I said, a lot of things to consider. Even if you get past all of that, the Texas Family Code does put limits on the duration of spousal maintenance. So, for instance, a court cannot award it for longer than 5 years if the parties were married at least 10 years, but less than 20. Or if it was granted just based on the family violence. The court cannot award it for longer than 7 years if the parties were married at least 20 years, but less than 30. And the court cannot award it for longer than 10 years if the parties were married for at least 30 years or more. So that's the duration limits, and a court must limit the duration of a maintenance order to the shortest reasonable period that allows the spouse seeking maintenance to earn sufficient income to support their minimum reasonable needs, unless the ability of the spouse to provide for the spouse's minimum reasonable needs is substantially diminished because of physical or mental disability, duties as the custodian of an infant or young child of the marriage, or another compelling reason. And so there are also limits to the amount being awarded. The maximum spousal maintenance that can be awarded is either $5,000 per month or 20% of the spouse's average monthly gross income. All right, on to the next topic. Discovery is a process that I'm sure many of you have heard about. It can be a scary word sometimes because there is a lot involved. And I would say that the most important part, what you need to know about discovery in any divorce case, is that you have to keep excellent records. So for instance, saving copies of everything, all financial documents, medical documents, any kind of documentation, really, insurance, things having to do with your home and your job, all of that. It's going to be extremely important to keep good records of that and begin collecting that sooner rather than later. Because once you get into the discovery period of a divorce, the deadline is not as long as you think. So before you're even asked to start providing those things, it can be wise to start go ahead and collecting them, especially things like tax returns, things that take a long time to request and get back. That's going to be important. All right, the next topic would be custody. So involving children. So it's very important to answer some questions about that. Give me 1 second here. And so sometimes you'll hear what we call SAPSR, suit affecting the parent-child relationship. That is that's Texas's fancy word for custody. So there's different types of custody cases. We have original ones where there are no orders over the children, and those have to be put in place. So it would be just an original suit. There are modifications of suits that have already been finished. So where you have orders, but you're wanting to come back and change something in those orders. And then there is establishment of paternity. So for instance, if parents were unmarried or the child was born prior to a marriage, that might be the kind of case that you need to do. And for parents who are unmarried or for children who were born prior to the marriage, there are a couple of unique things, such as you're going to need either an acknowledgement of paternity, which is a document that's usually signed at the hospital with hospital administration personnel. And that basically is the father acknowledging that he is the father of the child. And so again, that's filled out and filed at the hospital when the child is born. And so the other option would be genetic testing. If there is no acknowledgement of paternity, that can be done, and you can petition the court to order genetic testing of a child to find out who the father is. Another topic I'm going to delve into a little bit because I find that it's another popular topic, a question we get a lot that also has some confusion around it, would be grandparents' rights. So this specifically refers to grandparents who want to seek visitation with their grandchildren, not necessarily conservatorship or rights over the kids. That would be a different scenario, but for the sole sake of visitation, the court may order reasonable possession of or access to a grandchild by a grandparent if the grandparent can meet the criteria for that. And there's 3 things that they have to be able to overcome there. The first one is that at the time the relief is requested, at least one biological or adoptive parent of the child has not had that parent's parental rights terminated. So they cannot have had their rights terminated. So the second one would be the grandparent requesting possession of or access to the child overcomes the presumption that a parent acts in the best interest of the parent's child by proving by a preponderance of evidence that denial of possession of or access to the child would significantly impair the child's physical health or emotional well-being. So they're going to have to prove that the child is going to be damaged somehow, physically or emotionally, if they're denied that possession. And the grandparent requesting possession or access to the child has to be a parent of the child. And that parent has to either have been incarcerated 3 months preceding the filing, or found by a court to be incompetent, deceased, or the parent does not have actual or court-ordered possession of or access to the child. So quite a few different qualifications there. Standing for non-parents to intervene into a custody case and seek custody, the Texas Family Code lays out some specific ways for that to happen as well. So for instance, foster parents or potentially aunts and uncles or family friends, anyone who is a non-parent who is wanting to participate in a custody case. I won't get into the weeds of that too much because that does go on quite a bit. But the more common ones we see are when there is a danger or a threat to the child's well-being. If they've had possession for 6 or more months, not ending more than 90 days before they file a suit, and a person who's a relative within the 3rd degree of consanguinity of the child's parents, of the child, if the parents are deceased. And so they would need to be related. And so those are the 3 more common ones that we see. So in Texas, we have, under the big term or umbrella of custody, there are 2 main things we talk about. There's conservatorship and there's possession. And in Texas, we have 2 different types of conservatorship. The first one is joint managing conservatorship, kind of a mouthful. Usually one of the parents will be given the right to determine the child's residency, and that's an exclusive right, but all of the other rights typically are going to be the same. So they would have equal rights over their children. That is presumed to be in the best interest of a child. And so in order to get the other type of conservatorship, which would be sole managing conservatorship, the party seeking that has the burden of proving that it's necessary because of either a danger to the child's emotional or physical well-being. And typically we will see something like domestic violence, a serious criminal history of the parent, or substance abuse of the parent. And so if joint managing conservatorship is not appropriate, then a parent could seek sole managing conservatorship over the child, to where most of the rights of that child are stripped from the other parent and solely given to the one parent. So for possession, or what some people call visitation, we have a couple of different types of those as well. The most common would be what we call a standard possession order. And that looks like the typical 1st, 3rd, and 5th weekend of every month that you hear about. It also has some extended summertime for the parent with whom the child does not live. Holidays are split. So usually that's going to be either switching between the parents on odd and even years. And sometimes for longer breaks from school, it will look more like those being split in half between the parents. And so if you want to find out more about the details of a standard possession order, you could go to the Texas Family Code about that as well, and the Texas Family Practice Manual, or you could talk with an attorney who would kind of break it down for you. Sometimes there are charts online that you can look at, but those aren't always going to be most updated. So be cautious when you're looking at those. But any final decree of divorce or order in a SAPSR is going to lay out very specifically what, who gets a child when, what the exchanges are going to look like, where they're going to take place, things like that. Another type of visitation or possession that we see is supervised. And so if you're able to prove that a child would be impaired either physically or mentally, or somehow endangered by the other parent with just the regular standard possession order, then you could petition that the court put into place only supervised visitation. Usually that's going to be temporary. So it's not going to last the entire childhood up until the child turns 18 in most cases. And it has a very specific purpose, and it's designed to protect the children, but it's also designed to try to foster a safe and healthy relationship between the parent and the child, in hopes that there can be some rehabilitation or a reintroduction period sometimes. And so usually that's going to be temporary, and it can be through either an agency who specializes in supervised visitation, and that the parent and the child would show up there and somebody would be supervising the entire, paid to supervise the entire time. Or it can be through an appointed person. So sometimes we'll see parties agree on who they want the supervisor to be. And so that can be a grandparent, it can be a pastor, or anybody who's willing to serve as the appointed supervisor. And so that's supervised visitation. Another creative option that we see is called a step-up plan. And sometimes those work very well in families where there needs to be that period of reintroduction or testing the waters a little bit to see how things go. And so that can look like for a certain number of visits or a certain period of time, there are access or some sort of very specific, more rigid terms for possession and access of the child. And then after they cross that bridge or check off that part of it, they'll move on to the next phase. And it will usually be a little less restrictive, but it will still have some specific terms. And then a lot of times by the third or fourth step, they will graduate into a standard possession order, so long as things are going well and they've met all of the requirements on the previous steps. The next thing we'll talk about is child support. And the Texas Family Code lays out specific statutory guidelines for child support. We typically see, unless you're making less than $1,000 per month, in which case there are special provisions for that. For one child, it would be 20% of the obligor's net monthly resources. 2 children is 25%, 3 is 30, 4 is 35, 5 children is 40, and then 6+ children, it would not be less than the amount for 5 children. Even if a spouse is making minimum wage or not being employed, they will still be required to pay child support in Texas. And so we do have new low income guidelines, and that's about 5% lower for each category, depending on the number of children. If the parent who's being ordered to pay child support has children from another relationship for whom they're already being ordered to pay child support, the percentage will also be slightly lower because in a new order, because that's going to be taken into account in that calculation. Another thing that we have in Texas is called cash medical support, and that's for children who are being covered by Medicaid. So if your child is on Medicaid, the person who is paying child support will usually be required to pay a certain amount per month to reimburse the state for the medical coverage that it's providing. As far as duration, child support goes until a child turns 18, or sometimes it can go longer. Usually we see that happen with disabled children who are in need of ongoing support. And so if that's your situation where you have a child who's disabled, then it would be wise to request the court to order child support for longer than 18 years of age. COVID does not stop child support payments for any reason. Sometimes a parent being incarcerated may affect that to a degree, but you'd want to talk with an attorney to make sure. The Office of the Attorney General or an attorney can file an enforcement against an obligor who is failing to pay child support. And the consequences of failing to pay for child support would be interest and arrears, as well as even potentially facing jail time. So Texas does take it very seriously, and there are remedies for enforcing the payment of child support. A lot of times, most times in cases where child support is being ordered, a judge will sign what's called a wage withholding order, income withholding order, some call it. And that is where money is ordered to, or an employer is being ordered to withhold child support from the obligor's paychecks. And then that amount is sent directly to the state disbursement unit. And then the state disbursement unit will send the child support payments to the other parent. Another big topic in family law, specifically relating to domestic violence and abuse, is protective orders. And if you or someone that you know is needing a protective order, or you think that you might need one, we very much encourage you to contact us as soon as possible, because that can be, time is of the essence, and it would be important to get that filed soon. A lot of times district clerk's offices locally or county clerk's offices also help with applying for protective orders. So that's another resource. And in Texas, we have various types of protective orders. We have what's called a family violence protective order. That is where typically we see physical violence involved, and not so much verbal or emotional abuse, but physical violence, danger to you. And so if a protective order is granted, family violence protective order, then those last up to 2 years. And that's the statutory baseline for that. But it can be longer in certain circumstances, depending on the type of the underlying crime, whether the innocent party experienced severe injury, and whether or not that's the offending party's first protective order. The elements to get a family violence protective order are two things. You have to meet two prongs of that test. The first one is that family violence has occurred. You have to prove that that has happened. The second would be that it's likely to occur again. And the first prong of that test is usually not too difficult to meet. You simply have to prove that it's happened via police report or conviction or pictures, testimony, things like that. The harder part is proving that it's going to happen again, right? Convincing a judge that you need a protective order because that violence is likely to occur again. And typically in deciding that, judges will look at how severe the act of violence was, the level of injury sustained. At that point, they will consider verbal threats or threats of future harm, things like that. Family, under family violence, includes dating relationships. So that word can be a little bit misleading, but there is a statutory definition for the type of relationship that's required for a family violence protective order. So if you think that you might qualify, be sure to contact an attorney and we can help you decide whether or not that would be a good course of action for you. Another type of protective order is a sexual assault and trafficking protective order. The only element that you're required to prove to get a sexual assault or trafficking protective order is that a sexual assault or trafficking has occurred. And that can be a little more difficult to prove because you're looking at things like medical exams to help prove that, or other testimony from someone other than the victim sometimes, things like that. So if you can prove that that did happen, then you meet the elements for obtaining one. Now, the duration of a sexual assault or trafficking protective order would be for the lifetime of the offender and the victim, or for any shorter period stated in the order. There's also a stalking protective order. Again, that can be a little more difficult to prove. The only element required to get that would be that you prove that stalking has occurred. And the duration for that would be up to 2 years, unless there was serious bodily injury that occurred, or they were the subject of 2 or more previous protective orders. Now, we have in Texas, nationally, through VAWA, the Violence Against Women Act, what's called a full faith and credit provision. And so that is a federal law that states that all valid protective orders that are granted in the United States receive full faith and credit in all state and tribal courts within the United States, including the US territories. And so the full faith and credit means that each state has to enforce out-of-state protective orders. And they have to do that in the same way that they would enforce a protective order from their own state. That means that if the abuser violates an out-of-state protective order, that he or she will be punished according to the laws of whatever state they're in when the order is violated. So that is nice to have. I'll talk a little bit about safety planning when leaving an abusive partner. This is an extremely crucial step in any situation involving domestic violence. It's very personalized and tailored to an individual's needs. So if you are needing an individual safety plan, then you're going to want to contact one of us at Lone Star Legal Aid, or perhaps a counselor who specializes in domestic violence. And they can help figure out a safety plan that works for you. So the things I'm going to talk today about are a little more general, but they are very important for every case of someone who is a victim of domestic violence and hoping to become a survivor. So the first one would be get prepared. And that looks like getting together all of your finances, all of your information about your bank accounts, pulling out cash where you need to do that, and having that kind of saved and put in a place where your abuser does not know where you're keeping it. Sometimes that looks like giving it to a trusted friend or family member for safekeeping, or putting it in a safe deposit box at a bank where only you have the information for that and ability to access that. And the same goes for anything that you're collecting, such as paperwork, clothes, anything. You can have someone hold that for you in the event that you need it. Any other important paperwork, again, for your house, thinking about insurance, life insurance, home insurance, car insurance, copies of your driver's license and all of your credit cards and debit cards, anything you can think of, maybe even birth certificates for children, school records, medical records, things like that. If you have any medical equipment, medications that you rely upon, that would be wise to have a backup of those and save those, so you're leaving last minute or at the drop of a hat, you have access to those things. Clothes, of course, you're going to want to have some clothes ready in case you have to leave with nothing but the clothes on your back. Any kind of heirlooms, things that are precious to you that you are concerned that the abuser might break or sell off or hide from you to try to get back at you. Those kind of things you're going to want to put in a safe place. Pets, you want to have a plan for your pets. A lot of times abusers will use pets as pawns or tools to get to a victim. So have a plan for how you're going to protect them as well. You're going to want to have spare keys to your house and your vehicle, because if your abuser hides or removes those, you want to have another set so that you can quickly access those if you need to. Anything else that you need or that is important. And so that's, again, why it's going to be a very individualized plan, because that looks different for everybody. And when it comes to phone and tech safety, these in 2022 is absolutely paramount that everybody educates themselves on the safety of electronics. We live in a technological world where things are changing rapidly, and we have some scary ways of accessing information, people who are trying to get that from us. And so we need to be aware of tech safety. So sometimes that looks like deleting any apps that you don't know what they are. For instance, you can have an app on your phone that may look like something very benign, but it's actually a tracking app. And so any apps that you don't specifically install on your phone or that you don't know what they're for, delete them. Turning off geotagging and location services is extremely important for victims of domestic violence, because that can easily give away your location. Even the data in a photograph that you post to Facebook can be very dangerous. Have an expert or someone from your phone company assess your phone for any kind of bugs or tracking apps or devices. They'll usually be happy to do that for you. Another thing would be to use a virtual private network. If you're not sure what that is, it can be as simple as a Google search and moving into it. There are free options and low-cost options for that that make it very hard to track someone's whereabouts in their cell phone. Change your passwords regularly and use passwords that people, specifically the abuser, would not easily guess. Children should not have phones during this time while you're going through a divorce involving domestic violence. It's simply too much responsibility for them. And it could be difficult for us as adults to protect ourselves and our data and our location. So don't put that burden on your children and take that risk. Change your number, block numbers, delete social media during a divorce involving domestic violence. I have told people it is safer to just delete the entire app. There are ways of making it secure, but it can be very, very hard to do. So for instance, if there are mutual friends that you're friends with, the abuser's friends with, which is common, that could compromise your safety. So it's usually best just to delete it while it's going on. Keep things charged. Keep your batteries charged on your computer, on your cell phones, have backup batteries. That's going to be very important as well. Let's see, another thing would be emergency contacts. Keep those updated regularly and have a plan. You want to make sure that you have a secure location that you can go to in the event that you are running away from an abuser. For instance, that could look like a shelter. You'll have to call, of course, when you leave and make sure they have availability, but it can also be someone's home, someone that you know, someone that's a family member or a close friend, preferably someone the abuser doesn't know. But that can be very helpful to have a place to run if you need that. Another important thing would be maybe having a code word, for instance, for someone to call law enforcement. So if you want to text your best friend a certain word and they know that that word, if they receive that, means call 911 immediately and send them to your address, that can be life-saving. You want to be able, the idea is to have everything in a minute's notice, whether it's a notification to someone who knows what to do, or a bag ready to go, or cash hidden somewhere. Those are all going to be really important. You're also going to want to notify key people who are in your life and in your community. There's power in numbers. And so, for instance, if you are in an abusive situation, notify the school personnel where your kids go to school. Notify the people you work with. Notify your family, your friends, and your neighbors to be on the lookout, because that can really help. There is a lot of psychology behind both abuse and abusers, as well as victims of abuse and what they experience. There's a whole lot of judgment, and you'll hear people ask, why didn't they just leave? It seems so easy, but we who are trauma informed and who have walked with people through this, we know that it is a very, very difficult decision. And it's a very, very difficult thing to do practically. If you think about having to leave behind your home, your family, money, access to certain things, it can feel impossible. And so be patient if you know somebody who's going through that. And if you're going through that, give yourself some grace and perhaps seek out some professional counseling that can help you make that plan and get ready to take that step. I would say that if you are unsure if you're in an abusive situation, which we do find happens, because when you are in that kind of situation, sometimes it can feel like home and that can feel like normal. And what you might think is normal is not normal. And in fact, it could be a very dangerous situation for you or your children. And so there are some tools that you can use to figure out if what you're experiencing is abuse. My favorite tool is the danger assessment tool. You can Google that, it will pop up. And it's a short quiz where it asks you questions. You fill it out. Each question has an answer ranging from 0 to 5 or 1 to 5. And at the end, you add all of those up and it will tell you what level of danger you're in and more information about that. And sometimes it's shocking to people to see that, wow, what they're going through really is abnormal and dangerous. And that can be a very eye-opening tool. Another one is the power and control wheel. You can also Google that as well. It's a tool that I really like and that a lot of domestic violence counselors like, and that shows people how that cycle of abuse works, because it is a cycle. And you've probably heard of the different stages, including the honeymoon stage where you'll have like a blow up and something terrible happen, and then an apology and things are going well for a while, and then there's a tension building phase that results in another blow up. And it can also tell you on the power and control wheel different ways that abusers use power and exhibit control over their victims that you might not be aware of. And so that can be something helpful to look up. But again, always feel free to contact a counselor. A lot of the women's centers, Fort Bend Women's Center locally has free counseling. Houston Area Women's Center, Montgomery County Women's Center, all throughout Texas. We have many organizations and wonderful agencies specifically geared to help survivors of abuse. And so most of those resources are free, and you simply have to reach out. And so if you're needing help with that, reach out to someone who might know. We at Lone Star Legal Aid are happy to refer you to local community partners and other resources that you might be eligible for, in addition to what we do every day, which is the legal part. And so whenever someone is ready to take the step requiring legal action, such as a divorce, custody, protective order, you're welcome to reach out to us, but we're also going to refer you to these other outside resources that might help with other more social service type aspects. So that's it for today. Again, if you or someone that you know is needing legal advice for your situation, give us a call at 1-800-733-8394 or visit us on our website at www.lonestarlegal.org. Thank you for joining us.